So I just want to say thanks, Mark and Maria, for coming in today. Really appreciate it. I just wanted to highlight one of the things from your plan that I noticed. Wanted to go over your estate planning goals, and I know that that's something that you guys are both curious about. You know what the probate actually means, going through what Mark's estate actually is worth and valued at today, as well as the different documentation that actually goes into estate planning. So the first thing that I wanted to go through was the state adopted probate process. So basically this is the process that every state has adopted, and it's the legal disposition of assets from the decedents to their heirs, so how they want to move their assets and such. And all the assets in an estate go through this process unless they have a proper beneficiary designation, so the state knows, for sure that for example, Maria should be if you feel as though you want her to be your 401k beneficiary, that wouldn't go through probate because, you have a proper beneficiary designation, so on and so forth. And then I know you guys wanted to know, what Mark's probate estate included. So what that would include for him right now would be his brokerage account, because that does not have, you guys didn't indicate that had a proper beneficiary designation. So right now, so we would include that. We would include his first mutual growth fund. We would also include the value of his truck, his boat, and then his life insurance policy, because of course that life insurance policy, the beneficiary is the estate, so that would go directly through probate. So all of that totals around $217,450, which you can see more details of that in the plan that I provided for you guys. And basically, what's so important about estate planning is that it really sets up a plan for your children, for your family, to know exactly what you guys want to have happen, in the event that one or both of you pass away. And so what you want to do in this process is get together with the proper attorney to draft the documents and name the following fiduciaries that are really going to affect, the rest of your children's lives and the assets that you've left behind. So the first thing that you want to make sure that you get is a will. And basically this is just stating everything that you want to have happen, from, who your assets are going to, who gets what, and things like that. It lays everything out so that there's not a question for the state as to, well, they didn't explain this or they didn't explain that. So it lays everything out for everyone, so it's clear, it's concise, and it's fair. And so I would suggest a simple will for you guys, just because you're not going to run into any estate tax issues there. So I think, drafting the proper simple will with an attorney would be just fine. And then the next thing that you guys want to focus on, in my opinion, is establishing 2 revocable living trusts, one in Mark's name and then the other in Maria's name. And the reason for that is if you put your assets into the revocable living trust, they won't go through the probate process and they'll go directly to whoever the beneficiary designation is for the trust. As long as they're funded while you guys are living there and have the proper beneficiary designations. And another thing about that is, I know Maria has Ricky and James. You want to make sure that the trust entitles, everything that's supposed to go to everyone. Mark, maybe your trust can have more details on what's supposed to pass to Emma. Since Maria has, 2 other children, you want to make sure that you want each child to get exactly, what you want them to get. And that would be the real reason for those trusts. And then you also want to make sure that you have the proper durable power of attorney form set up for each of you. I would get a non-spring power of attorney, saying as though, you both are spouses. And the most important thing about the durable power of attorney that you need is to make sure that the crucial healthcare decisions are in each document of the power of attorney, so that in case of, one person's incapacitation, that you have in a written form, so that there's no arguments and things like that. It's very straightforward. On what can happen. So you want to make sure that, healthcare decisions on on each other's behalf in case, one person becomes incapacitated. That's really important, and it makes things go a lot smoother if those events were to ever come up. Next thing that I think is really important is having a personal letter of instruction. So basically this is going to go to the executor of the estate, just laying out, the funeral details, just where the important documents are located, such as the will or the durable power of attorney, the fiduciaries that you're going to name and the guardians for your children, the trustees, all of that. So it's just a simple letter. And so what's different between this and a will is that usually, you can tell the executor of your estate, you can show them to them before death so that they know where to find everything, how you want the funeral proceedings to go. It just makes things a lot smoother. And then, the other things that I think are really important as well, obviously you have to name the executor of the estate, and this is someone that should have, your utmost best interest in heart, because they're going to be dealing with everything, divvying out, obviously the estate, the trust, if you guys decide to implement those, and then letting the guardian know if the children are still minor, letting them know how to proceed as well. So you want to make sure you have no conflicts of interest with them, they have integrity, loyalty to both of you, and that they do have some financial experience as well. And the next thing you're going to want to do is name the trustee for any trust. So same kind of thought with the executor. These people can be the same person, but they don't necessarily have to be. You want to make sure that the trustees have some financial experience as well as some tax experience and record keeping. You also want to make sure that you're going to name a guardian for the children, because they are minors right now. That's very important. You want to make sure that this person is super empathetic, that you could see raising their kids as their own, and that someone that you really trust to take over raising your children. It's a really big important one as well. And I know you guys were thinking of Sarah as your guardian, and as long as you trust her and you feel confident that she would raise their children as their own, I think that's great. You can definitely name her as the custodian and the guardian of your children. But I do see that you do have her as a contingent beneficiary for the retirement accounts, and I just think that there may be a little confusion about what that actually means. So that means that, Mark, if something were to happen to you, the account will go to Maria, but if, God forbid, if both of you were in a car accident at the same time, the account would actually just pass through to Sarah. She has no obligation to give to the children or anything like that. So if you can revisit that beneficiary designation, I would just highly consider that to make sure that the assets are going to, exactly who you want them to go to, and have it, stated exactly how you want, so that you can make sure that the children are being taken care of. Because I know that was, one of the highlights of this plan is to make sure that we had a proper estate plan in place. So I just wanted to go over those aspects with you, and thank you for coming in today. I really appreciate it.